Hello, Crime Squad. Welcome back to my channel. This video is the defense's closing argument. I'd like to hear your comments on whether you think the judge had already decided prior to the closing argument his decision on the case, or do you think he actually took them into consideration, both for the defense and the prosecution? Again, this video is the defense's closing arguments. Just want to hear your thoughts on the judge's decision. And also, as always, please remember to like, share, comment below, and subscribe to the channel if you have not already. So let's get started.
So the court came back in to see if there was any further evidence or testimony, which appears there's not, and if there was any further argument regarding sentencing. Subsequent to that, I will take another recess, and then we'll come back for the court to issue a sentencing order at that time. So that's procedurally where we are.
Yes.
Okay. All right. So is there any further argument then?
Yeah, you want to get voting?
Yes.
Judge, briefly, you've heard all of the evidence, the testimony in the case. On behalf of myself, Mr. Hollander, Ms. Perez, Mr. Wilson, we want to thank you for your consideration of Mr. Wilson's sentence in this case. We understand that when a jurist takes the bench, you hope you don't have to make a decision like this, but we know that Your Honor has paid close attention. You've considered the law, you've considered the facts, the evidence, and you're going to render the decision that you think is just. Obviously, it's either sentence is a terrible sentence. The sentence of death is worse in that if there is a mistake along the way and we can't correct that mistake, we can't correct the sentence after it's imposed. We'd ask that the court consider the three statutory mitigators: the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of the law was substantially impaired. Obviously, you've heard testimony that he consumed quantity of controlled substances. He described it to the officers, said it basically made him almost insane. Defendant requires specialized treatment for mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. We don't know what kind of treatment that's going to be on death row. We know that he needs treatment. There's testimony to the fact that he's been on treatment. He's been on the same treatment throughout his stay in the Department of Corrections and in the Lee County Jail. He needs that medication. He needs that treatment. Defendant cooperated with the state to resolve the current offense or any other offenses. I'm sure the court recalls that Mr. Wilson provided a statement to law enforcement. At the time he provided the statement, he was not aware that they had located the second victim. He was doing that in an effort to assist the victim's family. They had already located the second victim, but he didn't know that. He provided them with details that, but for his statement, they would never have known. We have non-statutory mitigating circumstances. Defendant was born to drug-addicted teenage parents. The defendant's biological mother suffered mental illness. Defendant's mental illness presented at age 12 and was precipitated by puberty and substance abuse. Defendant was diagnosed with bipolar disorder and I call it schizophrenia. It's a little bit different diagnosis. Defendant is loved by his adopted parents, Candy and Steve Wilson, who has provided a statement to the court. Defendant is loved by his sister, which was reflected in the statement read to the jury. Defendant was profoundly affected by being abandoned by his biological parents. He's been a loving son to his adoptive parents, as reflected in the statement read earlier today. I remind the court that the jury's recommendation was 9-3 for one victim and 10-2 for the other. Under their previous statute, that would have required this court sentence my client to life. Likewise, I would remind the court that Mr. Wilson has been waiting trial for a long time. The unfortunate death of his previous counsel prolonged the litigation and impacted Mr. Wilson greatly. I point out to the court, lastly, obviously the court has received, and I know that you haven't read them because I have received notification from your office that these letters have been received by your office, but I know that the court would not read an ex parte communication. The letters have been sent back to us, but obviously there are people that have been pleading for Mr. Wilson's life and for the court's mercy. There are some 40,000 people that have signed petitions to that effect. We'd ask the court to take into consideration that death is permanent. Death is different. And we're asking the court to impose 2 life sentences for Mr. Wilson.
As always, Crime Squad, it is a joy and a privilege to bring you this Crime Squad coffee. That's it for today, but please drop down in the comments to connect with our Crime Squad community. And for anyone new here, please subscribe to the channel, give us a happy thumbs up, and we'll see you in the next video.